The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to call us at 515-207-2006. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We serve all of Iowa. We're also happy to meet with you and provide most legal services virtually without requiring you to leave your home. Enjoy the video.
Hello, I'm Gene Nassif, an attorney at O'Flaherty Law. My practice areas include business transactional matters as well as some landlord-tenant issues. Now, today we're going to talk about whether a will or deed takes priority in Iowa. We're going to cover the factors that are considered and in which situations either a will or a deed will take priority. Now, how does the deed impact the title of property? As we've discussed in some other videos, it's important to understand the difference between the deed and the title of the property. A deed is a physical document transferring title of the property from one person to another in a way that evidences the transfer of the property. The title describes how the property is owned, the right to use and to modify the property how the owner sees fit, and the owner's ability to transfer interest or a portion of the ownership to others through a deed. Under Iowa law, a deed for buying or selling a home must be drafted, signed, and notarized. Then it has to be entered into the public record by the county reporter as evidence of the transfer. It must contain the names of the current owner and the new owner, the legal description of the property, and it must be signed by the person transferring the property. The title is included in the deed and describes the ownership of the property. Sometimes the grantor, the person giving the property, must leave property to more than one person. In Iowa, a title can describe ownership of property by more than one person in a few different ways. The major ones are tenancy in common, joint tenancy with rights of survivorship, to just name a couple. Now, how might a will and deed have a conflict? A will may list one or more beneficiaries of a title, but the deed lists another name. The deed may also not match the name listed on the will. As this can create confusion for courts, personal representatives, and interested parties, it's important to make sure the will and the deeds match up with the person's actual intent. Now, what documents will override a will? There are a few different things that will override a will, notably the beneficiary designation on a life insurance policy or a 401k, a living trust, or a right of survivorship on a joint tenancy title. If a decedent owned a property in joint tenancy, their ownership interests would pass immediately to the co-tenant upon their death, regardless of what the will says. If the property was owned by tenants in common, the decedent is free to distribute their property interests in the will. Living trusts, trusts created during the decedent's lifetimes, and beneficiary designation in life insurance policies or 401ks will also avoid probate. Now, what if there is a question about whether a joint tenancy exists? In the absence of evidence the grantor intended to create joint tenancy with rights of survivorship, the court will imply the owners hold the property as tenants in common. The court will review the intent of the parties to view whether joint tenancy was created. The court used to rely on a formal process called the 4 units: interest, title, time, possession. While proof of these may be helpful to Iowa courts, they don't necessarily show someone intended to create joint tenancy. It's a bit more difficult to end or sever a joint tenancy. Intent of parties is examined closely, but there must be some action. An instrument or document must be created showing the intent to sever the joint tenancy. One party may sever the joint tenancy on its own, which is called a unilateral severance. If the only document which shows the person intended to sever the joint tenancy is a deed, which is faulty or unenforceable, the courts have held that this will not sever joint tenancy. Additionally, if the property is a homestead under the law, these protections for a surviving spouse who wishes to continue living on the homestead remain. One spouse cannot sell or otherwise give away property unless both spouses agree in writing. If the court finds there's a joint tenancy that has been severed, the owners will hold the property as tenants in common with no rights of survivorship. When the owner dies, their property interest would enter into their estate. This is a difficult area of the law, and if you have any additional questions, feel free to reach out to our firm. Thank you very much, and have a nice day.
Hello again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed this video and podcast. If you did, we'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please do not hesitate to reach out and schedule a consultation. Most consultations are free and all can be conducted remotely if you'd like. Please email us, book online, or call us at 515-207-2006. We have many locations for your convenience. We serve all of Iowa. Thank you again for watching.